Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we're learning about permissions to reapply for admission. Now, when do you need to do this? Well, of course, it's after you have an order of deportation. And if you're in the middle of deportation proceedings or removal proceedings and you leave voluntarily, you also will have to file permission to reapply because you're just self-deporting yourself. Now, a grant of the request to reapply for admission, what that does is that waives inadmissibility resulting from all prior removals and all subsequent entries. So once you get one approved, whether you've re-entered illegally one time or 12 times, it should work for all of them. So you don't need to do a very specific permission to reapply for each entry. You just do it one time, and of course you wait until the answer in order to go forward and don't re-enter the United States without having the answer. Now, the question is, what procedures really do you need to use in order to come in on this? But initially, more importantly, what are the requirements and standard of exercise of discretion to get this granted? Well, first of all, it's USCIS who's going to rule on the permission to reapply. And they have very broad discretionary authority when it comes to evaluating requests for permission to reapply. Basically, there are no prerequisites such as qualifying family members. So, with many of the other waivers, most of the other waivers, there needs to be a qualifying relative, which is, you have to have a spouse who's a U.S. citizen or lawful permanent resident. Here, you do not. They will look at all of the evidence in order to decide. So each case is taken on a case-by-case basis, and it takes the favorable factors versus the unfavorable factors. Now, some of the positive factors in granting a permission to reapply might consist of family responsibilities in the United States, the applicant's good moral character, the applicant's respect for law and order, evidence of reformation and rehabilitation, hardship to the applicant and others, the need for the applicant's services in the U.S., and whether the applicant has an approved immigrant or non-immigrant visa petition. So those are just some of them. It's not all of them. Some of the negative factors include repeated and significant immigration violations and the existence of other grounds of inadmissibility. So, of course, where you have to present those, you don't have to, have a book on exactly all the bad stuff either. You can minimize those and really maximize the good stuff. Now, in order to use this, you have to understand that the purpose of it is to alleviate the multi-year ban because of a deportation order. So it basically, after you get a deportation, it gives you a chance to remedy the situation in order to come back into the U.S., or if you're here, in order to stay, basically. And if done properly, there are reasonable chances of success, but definitely you have to include as much good factors as possible in order to be able to have a realistic chance of success. Okay, more in the coming videos.